All right, welcome to The Explainer. If you're an aspiring barrister, listen up. Today, we are breaking down an absolutely essential tool for your litigation toolkit, Section 32 of the Federal Court Act. This is one you've got to know.
So, picture this. You get your first big brief. It's juicy. You've got a solid federal competition claim, but it's all tangled up with state-based contract issues, maybe a common law duty of care claim in there too, and your first thought is, oh no. Am I really going to have to run this case in multiple courts? What a procedural nightmare. Is there a better way?
You bet there is. And here's how we're going to get there. First, we'll unpack that jurisdictional puzzle. Then we'll look at the elegant solution that is Section 32. We'll explain its two critical streams, clear up the common confusion between associated and accrued jurisdiction, and then wrap it all up with a practical checklist you can take with you.
Okay, so what's the core problem we're trying to solve here? It's all about avoiding the split case. You see, in our federal system, courts have very specific lanes they have to stay in. Without a tool like Section 32, a single dispute, one set of facts, could get chopped up and fought across different state and federal courts. And that just means more time, more money, and frankly, the very real risk of getting conflicting decisions. It's inefficient and just a mess.
And this is where Section 32 works its magic. I want you to think of it as a statutory hinge. It's a special provision that lets the federal court swing its doors open a little wider. It can pull in these associated matters, like those state contract claims that would normally be way outside its jurisdiction. But there's a catch, right? There always is. It can only do this if those claims are properly connected to a core matter, a legitimate federal issue that got the case into the federal court in the first place. Now, this power isn't a free-for-all. There are some really important constitutional guardrails. The Act itself says it only works to the extent the Constitution permits. And what that really boils down to is this. Everything has to be part of a single, unified matter. That's the big idea from Fencott v. Mueller. It means all the pieces have to form one single controversy. You can't just use it to ask the court hypothetical questions, and you certainly can't use it to shunt federal power over to a state tribunal. These are the hard limits.
But, and this is a big but, within those constitutional limits, the courts have said Section 32 is meant to be powerful. In the case of Thompson Publications, they called it a wide and full grant of jurisdiction. The whole point is to be efficient, to let one court solve the whole puzzle. So, while there are limits, the intention behind it is definitely expansive.
So how does this wide and full grant actually play out? Well, Section 32 works through two completely separate pathways or streams, and it is absolutely critical. I can't stress this enough, that you know which stream you're in, because it all comes down to the nature of your core case.
And this slide lays it out perfectly. On the left, you've got the civil stream. This is governed by subsections 1 and 2, and it deals with associated matters. On the right, totally separate, is the criminal stream, which is governed by subsections 4 and 5, and it deals with related matters. And here's the key. They are mutually exclusive. If your main case is about an indictable offense, the entire civil stream is switched off. You can't use it.
Let's walk through the civil stream. First, you need your anchor, a solid civil core matter. Then you use subsection 1. That's the part that lets you attach those associated state or common law claims. Now, if the case goes up on appeal, subsection 2 has you covered. It makes sure the jurisdiction follows. And just to hammer it home, remember the big off switch. Subsection 3. It explicitly says this whole stream is off limits if your core matter is an indictable offense.
Okay, now for the criminal stream. Here, your anchor has to be an indictable offense. Then you'll use subsection 4 to attach related matters, but notice the difference. They have to arise under another Commonwealth law. Just like the civil side, subsection 5 carries that jurisdiction up to the appeal level. And if you're ever fuzzy on what exactly counts as an indictable offense matter, subsection 6 gives you the precise definition. So it's subsections 4, 5, and 6 for criminal.
And listen, this isn't just some dusty old academic point. With the big 2024 expansion of the federal court's criminal jurisdiction, this stuff is more relevant than ever. The court is hearing way more corporate crime cases these days, especially from ASIC. So knowing how the criminal stream works under subsection 4 is no longer a niche skill. It's fast becoming essential for any serious commercial practitioner.
Okay, let's tackle something that trips up so many people. The difference between associated jurisdiction, which we've been talking about, the power from Section 32, and the judge-made idea of accrued jurisdiction. They are very close cousins, but they are not the same thing, and you need to know the difference. And this table just nails the distinction.
Accrued jurisdiction, which is judge-made, is about the court's inherent power to decide all the different legal bits and pieces of a single case, a single controversy. Think back to our very first example, the federal competition claim. That's all tangled up with a state-based contract. That's accrued jurisdiction. Section 32's associated jurisdiction, on the other hand, is a statutory power that lets the court bring in a separate but related matter. It's about joining two distinct claims.
The classic line on accrued jurisdiction comes from the Philip Morris case. The High Court basically said that once a court's federal jurisdiction is properly triggered, it has the power and the duty to decide the whole controversy. It's not going to just deal with the federal part and then tell you, sorry, you've got to go to another court to finish the story. It gets to resolve the whole thing.
So how do you know if different claims are really part of that single controversy? Well, Fencott v. Muller gives us the test. The court asks if there is a common nucleus of facts. It's a practical question. Do these claims all spring from the same events, the same relationships? Are the facts so interwoven that it just makes no sense to try and separate them? If so, you've likely got a single controversy.
So let's pull all these threads together. Let's make this really practical. Here is your 4-step checklist for putting Section 32 into action when you're on your feet. Okay, number 1, find your federal anchor. You must have a legit core federal matter. And remember, if that anchor claim gets struck out or fails, your associated jurisdiction sinks right along with it. 2, choose your stream. Is your anchor civil? Then you're using subsections 1 and 2. Is it an indictable offense? Then you're in the world of subsections 4 and 5. 3, prove the factual connection. Get out your Fencott v. Muller test and show that common nucleus of facts. And finally, 4, remember the appeals rule. That jurisdiction on appeal only follows the associated slice of the case thanks to subsections 2 and 5.
So there you have it, the Section 32 playbook. It's an incredibly powerful tool for creating efficiency and coherence in your cases. Which kind of leaves you with the final question to chew on. Think about some of the big, messy commercial cases you've read about in the news. Which one of them could have been run smarter, cleaner, and more efficiently if the lawyers had used this statutory hinge right from the start?